Good afternoon and welcome to today's webinar looking at how coronavirus might affect your business and steps that you might be able to take to mitigate the impact. This is an issue that continues to evolve quickly, so we're going to focus on some general principles today that should help you to continue to operate while protecting your employees. Consider some of the affected supply chain issues and also look at how you might be able to assign liability for loss that's caused by the outbreak. Before we start the webinar, we just have a few small housekeeping points. Firstly, to keep background noise down, we've placed each of you on mute. There's going to be an opportunity to ask questions at the end, but you can also use the chat function throughout the webinar in order to ask any questions you have as we go. We're going to try to keep to about 30 minutes today, but given the changes that have taken place over the last couple of days, we'll maybe run slightly over. So if you have to dial off, we'll circulate a recording of the webinar after today's presentation as well. You have three speakers today. My name is Matt Phillip. I work with businesses to help them resolve commercial disputes. Coronavirus is obviously going to put a strain on contractual relationships, and so it's important that steps are taken to mitigate them at this stage.
I'm Ali Rochester and I work in our trade and commerce team, helping clients manage and record their commercial relationships with purchasers, suppliers and other businesses.
And I'm Rebecca Nicholson and I work in the employment team here. We've been working with a number of clients to walk them through the different challenges that the virus creates for their workforce.
So as you probably know, novel coronavirus known as COVID-19 is a strain of coronavirus first identified in Wuhan city in China. On Wednesday, the World Health Organization identified COVID-19 as a pandemic for the first time. And yesterday, the government confirmed that the UK was moving from the containment phase of its strategy for responding to the virus to the delay phase. In today's webinar, we'll explore some practical steps that can be taken now to minimise the impact that coronavirus could have on your organisation. The government has published detailed advice for employers and businesses which covers how to help prevent the spread of coronavirus, what to do if someone with suspected or confirmed coronavirus has been in a workplace setting, what advice to give individuals who have travelled to specific areas, and advice for the certification of absence from work. ACAS have also produced an overview for employers and employees which sets out best practice to protect the health and safety of staff in the workplace and practical tips. The FCO is regularly updating its travel advice to give British nationals advice on what they need to know before deciding whether to travel and what to do if they are affected by an outbreak of COVID-19 while travelling. Finally, the Department of Health and Social Care is publishing daily updates which set out the risk level and advice about what to do when returning from affected countries. The advice is changing daily, but the primary advice is to self-isolate in order to prevent the spread of the virus. Links to all of these guides can be found in the resources section of the webinar presentation screen.
We're going to start today by addressing some of the employment issues facing organisations at the moment. Firstly, the most pressing issue for a lot of people is what will happen with pay. If an employer decides to close the workplace as a precautionary measure and staff are unable to work from home, then they should be paid as normal because they no longer have the opportunity to attend work. Current predictions are anticipating that up to a fifth of the workforce could be off at the same time. Employees or workers who are ill or self-isolating will be entitled to statutory sick pay, SSP, or any enhanced sick pay offered by their employer. As announced in the Chancellor's budget earlier in the week, where an employee is self-isolating, they will be entitled to SSP whether or not they are showing any symptoms of the virus. SSP will also be available to employees who are caring for those within the same household who are displaying symptoms and have been told to self-isolate. Normally, SSP is only payable from the fourth day of absence. However, the government has announced emergency temporary legislation which will mean that it's paid from day one for self-isolating employees or workers, as they are helping to prevent the spread of the virus and therefore should not be penalised for doing the right thing. SSP is payable by employers and is currently set at £94.25 a week, which equates to an extra £40 for those who are self-isolating under this emergency legislation. Only those who earn more than £118 a week are entitled to SSP, so lower earners will not be entitled to these payments. the Chancellor announced as part of the budget that the government will be introducing measures that will support small and medium-sized businesses to cope with the cost of paying coronavirus-related SSP. This is going to come in the form of government refunds on the condition that the following criteria are met. Firstly, the refund is for a maximum of 2 weeks SSP per employee. The employer must have fewer than 250 employees as at the 28th of February 2020. The employee has to have claimed SSP as a result of a coronavirus-related absence. And lastly, the employer must have a record of the absence. However, doctor fit notes will not be required. The payment of refunds to these businesses who fit the criteria will require a new mechanism to be set up by the government, and so that means that in reality employers are going to have to wait some time to actually receive these payments, despite the government's ambition to put this into place as soon as possible. If employees are able to work from home and they're fit to do so, then they can continue to work and be paid as normal during any period of self-isolation. If employees ask to take annual leave to cover this period, then employers should accept these requests unless there's a good reason not to. For example, if the employee can work from home and there's a business need that would justify refusing this request. Employers should avoid asking employees to take holidays during any self-isolation period, as employees cannot be forced to take annual leave without receiving sufficient notice in advance. For those who choose to stay away from work without being asked to do so, and who are not sick or self-isolating, the position is less clear and these employees may not be entitled to be paid. However, if the spread of the virus continues to accelerate, then imposing a no-pay position could be overly strict and affect staff morale. So we would advise employers be understanding but consistent in their approach. The next common question is whether employers need to close their premises if a member of staff is confirmed as having coronavirus. The current government guidance does not recommend this, even where a member of staff or a member of the public who is confirmed as having coronavirus has recently been within the workplace. The current advice is that the local health protection team will get in touch with the employer to discuss the case and then to look at identifying anyone else who may have been in contact with this individual, and then they'll advise on any actions or precautions that should be taken. However, employers have a duty of care to employees, and that includes the duty to ensure that they keep their work premises safe. And so if a member of staff is confirmed as having coronavirus, employers may wish to close their office or workplace as a precautionary measure. Certainly in recent days, we've seen a number of employers sending all staff home following a suspected or confirmed case of coronavirus. And just this morning, it was reported that Aegon had sent home 1,000 or so staff from their Edinburgh headquarters to work from home until further notice. My next question is whether employers can require employees to self-isolate. In line with government advice, employers can ask employees to self-isolate if they're returning from an affected country, and employers should be alive to the fact that allowing an employee who should be self-isolating to come into work could lead to a breach of their health and safety duties. For example, if this employee then passed the virus to another who could be more vulnerable to it because of an underlying illness or pregnancy. Employers could consider suspending an employee who refuses to self-isolate against the current advice, and often a contract of employment will state that an employer does have the right to do this. However, if there's no contractual right to suspend, then employers should look to take legal advice on the process to be followed to ensure they act lawfully. A final question that I'm going to cover, and this is a really important one for a lot of people, is what is going to happen if schools close or if employees need time off to look after dependents. So at this stage we know that the government is not closing schools. However, some schools have closed temporarily and a number of schools have sent pupils and teachers home, particularly following ski trips over the half term. Those with caring responsibilities may also have to take time off work to care for children or for elderly relatives. Employees have a right to take unpaid time off to deal with unexpected emergencies, and a school closure or illness of a dependent will fall into this category. And this entitlement exists in the UK to provide breathing space so that working parents and carers can deal with such emergencies. However, if a school closure is prolonged for a number of weeks or months, then arguably it stops being an emergency, and the onus then is placed on the employee to make alternative childcare arrangements. However, taking an overly narrow view of what is an emergency is likely to be counterproductive in the current climate. Parents are also entitled to take unpaid parental leave, and they can take up to 4 weeks per year for each child up to the age of 18. The statutory notice period for taking such leave is 21 days, but employers may have a shorter period in their own policy. And whatever the notice period is, employers may wish to be flexible when considering requests at short notice.
Thanks, Becky. The next area we're going to look at is supply chain issues. So worldwide, the full impact of the outbreak and the resulting emergency measures on international trade remains to be seen, but we are already seeing our clients experiencing disruptions to their supply and distribution channels. Companies incurring the greatest disruption at the moment include those that rely on international supply chains with a presence in affected areas, those that sell to customers in affected areas, and those that rely on people travelling in affected areas. However, the measures taken to prevent the spread of coronavirus are becoming increasingly pervasive, and with the increased measures announced in the UK yesterday, it's likely that businesses without a direct trading connection to affected areas will also start to feel the impact.
Yeah, and it's obvious that the outbreak is going to affect suppliers because they might not be able to fulfill their contracts within required timeframes, or possibly even at all, as a result of the emergency measures that are going to impact goods, workers and logistics. However, buyers might also be affected either as a result of disruptions in downstream markets or because there's an impact on their ability to take delivery under the contract. This means that businesses are at risk of either being unable to fulfill their own contractual obligations, or they suffer a loss because their suppliers can't fulfill theirs.
So when the impact will be felt by businesses may also vary depending on the business or the affected project. The key issues for businesses with supply chain disruption, or generally in its contractual relationships, will be where risk and liability lies for the delays or failures caused by the outbreak. As a result, many businesses are quite rightly starting to review their key commercial contracts to assess their risk exposure and understand their rights and obligations in circumstances of delayed or failed performance. Typically, where a delay results in a contractual failure, a claim for damages for breach of contract would be a possible remedy. However, where an epidemic or pandemic causes the contractual failure, a claim for breach may not be available because the contract contains a force majeure clause that applies, or they can rely on the doctrine of frustration. We'll come on to talk about how losses are allocated and frustration, but we'll take a look first at force majeure.
Yeah, and we're going to look at the position for the UK today. As with so many principles of contract law, there's very little difference between Scotland and England and Wales here. So whilst the key cases that we're mentioning are generally speaking English, they've also been applied north of the border. This means that one of the first steps when reviewing your supply chain contracts is to try to identify the jurisdiction and the governing law clauses, because they're going to determine how the rest of the regime is going to be implemented. So
in general, a force majeure clause will excuse one or both parties from having to perform its obligations under the contract in some way following the occurrence of certain events. However, the scope of force majeure clauses can vary significantly from contract to contract. The first key element to consider is whether the circumstances in question are covered by the force majeure provision. Because of its French law origins, the term force majeure has no recognised meaning in English or Scots law, so the contractual definition is therefore very important. We've got a couple of examples of definitions of force majeure on the next couple of slides. It's important to note that typically the definition of force majeure will be open or non-exhaustive, in that the particular circumstance doesn't need to be specifically listed as a force majeure event, provided it meets the requirements of the objective test, which is usually set out in the definition, which is that the circumstances are beyond the reasonable control of the affected party. So in this first example here, it's clear that it covers epidemic or pandemic, so the current coronavirus outbreak would be covered. Even if epidemic or pandemic isn't specified, the definition may refer to more general terms such as disease or illness, and that may be sufficient.
Similarly, where delays are caused as a result of emergency measures that are being put in place to try to address or to contain the outbreak, These may be covered by terms such as government action or government order. They can be seen in the second example. The final example is less clear. The requirements that events are beyond the reasonable control of the affected party may be sufficient, but it's obviously not guaranteed. And whether or not the coronavirus outbreak would be caught would depend on the drafting in the clause, the particular circumstances, the intention of the parties, and the extent to which that intention can be proved. However, it should also be noted that the courts have previously said that the proper approach to the interpretation of a force majeure clause is by reference to the words the parties have used, not to their general intention. It's important that there is at least some attempt at a definition or a test to be applied to determine force majeure. Previously, a clause which simply stated that usual force majeure clauses shall apply has been held by the courts to be void for uncertainty. And the second element to consider is how does the force majeure provision operate? Again, we have some examples on the slides.
So in the first example here, the affected party must be prevented from performing their obligations. The courts have interpreted this as being a fairly high test. Tenants against Wilson was a 1917 House of Lords decision, which related to a contract for the supply of magnesium chloride. The goods were largely sourced by the supplier from Germany, and as a result of the outbreak of World War I, the supply dried up. The court decided that to be prevented from performing the obligations, the relevant party must demonstrate that performance was legally or physically impossible, not just difficult or unprofitable. In the judgment, one of the judges noted that the argument that a man can be excused from performance of his contract when it becomes commercially impossible seems to me a dangerous contention which ought not to be admitted unless the parties have plainly contracted to that effect. So in the second example, having been hindered or delayed is sufficient to trigger the force majeure clause. These have a wider scope, and these tests will generally be satisfied if performance is substantially more onerous. Again, in the tenant's case, it was noted that preventing delivery means rendering delivery impossible, and hindering delivery means something less than this, namely rendering delivery more or less difficult, but not impossible. So the precise drafting of the relevant force majeure clause is therefore key to determining whether or not it will cover contractual failures arising as a result of the coronavirus outbreak.
Ensuring that the circumstances are covered by force majeure is obviously critical, but there's some other things you need to consider when you're thinking about whether you can rely on the force majeure clause. Firstly, it's for the party looking to rely on the force majeure clause to prove that the event or circumstances fall within the contractual provisions and that their non-performance was caused by that event or those circumstances. The party will also need to meet the causation requirements of that clause. It's important to note that the courts do not take lightly the matter of a party seeking to avoid obligations that they've freely undertaken. In the Seadrill Ghana case, the force majeure provision contained a causation requirement which was, if and to the extent that fulfilment has been delayed or temporarily prevented by an occurrence as hereunder defined as force majeure. The case involved an oil rig hire contract, and the court found that the contractual failure was caused by two matters, one a force majeure and one which was not. The affected party could not rely on the force majeure clause. Although a moratorium imposed by the Ghanaian government on drilling had been an effective cause of the lack of drilling, which was a force majeure, Ghana's refusal to approve a new oil field for other reasons had also been an effective cause, and that wasn't force majeure. The ultimate failure to use the rig had been caused by the refusal of approval and not the moratorium. This is a reminder to analyse whether the causation requirement is satisfied if you want to then try to rely on a force majeure provision, or if there are other factors which may be contributing to those contractual failures. Force majeure events can also not be used to mask underlying failures. If, even without the force majeure event occurring, a party would have failed to meet its contractual obligation, it can't seek to rely on the force majeure event to avoid liability. Again, that's important because it's all about the underlying circumstances. There will usually be a requirement to mitigate the effects of a force majeure or to use reasonable endeavours to prevent them. This can impose a significant burden on the party who's relying on the force majeure provision. In the Seadrill-Ghana case, the contract provided that both parties shall use their reasonable endeavours to mitigate, avoid, circumvent or overcome the circumstances of force majeure. In that case, the court stated that the affected party would need to take into account the commercial interests of the innocent party as well as its own when deciding what steps it can and should take to avoid or mitigate the force majeure event. The Court of Appeal in the Sealant case also said that any clause which included language referring to events beyond the control of the relevant party could only be relied upon if that party had taken all reasonable steps to avoid its operation or to mitigate its results. It's important to ensure that if you want to rely on the force majeure clause, you comply with any notice requirements, including at what stage the notice needs to be given and whether any updates or other communications are required.
Another point to consider is what the effect of triggering the force majeure clause is. Again, this will depend on the drafting of the provision. Typical effects of a force majeure clause are suspension, so the affected obligations do not go away or disappear. They're simply paused, and the relevant obligation of the contract will be reactivated once the force majeure event comes to an end. Removal of liability, so where the non-performing party's liability for that non-performance or delay is removed. Again, this is usually for the duration of the force majeure event. The obligation to mitigate, which Matt's just touched on, and also termination. In some instances, the contract will provide that either party or only the non-affected party can terminate the entire agreement if the force majeure event or the delay or failure caused by the event lasts for longer than a specified amount of time. So relying on a force majeure clause is therefore not as straightforward as just checking that the event in question is covered by the definition of force majeure. In the current circumstances, just because a force majeure definition includes reference to epidemics or pandemics, doesn't mean that the parties will be excused from fulfilling their contractual obligations. Whilst force majeure provisions are helpful tools in extreme circumstances, they can be very onerous for the affected party to rely on. A final quick point to note is in relation to force majeure provisions contained in standard business terms. These will be subject to the Unfair Contract Terms Act 1977, and so to be enforceable, such terms would need to satisfy the reasonable test under UCTA.
So, force majeure provisions are one way of trying to allocate the risk of a supervening event between the parties. Obviously, there are a number of possible areas of challenge or uncertainty when you're attempting to rely on them, but as a general rule, having a provision in the contract in the first place is a really useful starting point. If the contract doesn't contain a force majeure clause, then parties will sometimes need to look for other ways to try to manage their potential liability if the COVID-19 outbreak prevents them from meeting their obligations. That's where the doctrine of frustration comes in. When something occurs after the contract has been formed that renders it physically or commercially impossible for a party to fulfill the contract, there is an exception to the general rule of the doctrine of absolute contracts, which dates back to the 1700s and basically states that if a contract becomes difficult or even impossible to perform, the party that's in breach is liable in damages. If there's a force majeure clause in the contract, then the court will seek to apply that rather than to try to apply the doctrine of frustration. But before going into the detail of what frustration actually is and how it operates, it's important to understand the extent of our discussion today, mainly because there are different jurisdictions that have very different ways of trying to correct excessively onerous contractual provisions that arise from unforeseen circumstances. If you take Europe as an example, French law doesn't recognise frustration except in a very limited sense in public law contracts, whilst German law has a much broader doctrine that's based on an underlying duty to act in good faith.
So what is frustration, and is it possible that coronavirus could amount to a frustrating event? The courts have developed a set of general principles that it will apply when considering whether or not an event that occurs after a contract is entered into that prevents performance will trigger the doctrine of frustration. In general, a frustrating event is one which occurs after the contract is formed. This seems simple enough, but we'll come on to look briefly at some of the interesting questions for contracts being negotiated as the virus continues to spread. For contracts that have been in place for some time, this condition will be met. It must strike at the root of the contract. This means that the event has to impact the core purpose of the contract, for example, preventing the supply of goods in a sale of goods contract. Another way to think of this is whether a failure to perform the obligation would amount to a repudiatory or material breach. It must not be due to the fault of either party. Again, it seems clear that in the current case, provided companies are complying with available guidance from appropriate organisations and making reasonable contingency plans, then they could not be considered at fault for the impact of coronavirus on their operations. It must render performance impossible, illegal, or radically different from what was contemplated. And understanding what this means in a general sense is quite difficult, so it's often easier to look through examples of things that the courts have said previously weren't enough to amount to a frustrating event. So, for example, if there's an alternative method of performance available, or it's just more expensive to perform the contract. It's not enough if there's a change in economic conditions necessarily. For example, in the Gold Group case, the court held that a fall in property prices, which unexpected but not entirely unforeseen at the time, was not grounds for frustration. And in that case, the court noted that the contract included mechanisms that would have allowed the contract to operate even in a more difficult economic climate. The CTI case provided that it isn't enough that the seller under a sale of goods contract is let down by its own supplier. So the final point is an important one to note when you're in a supply chain. Where you're reliant on your own suppliers or subcontractors in order to deliver under a contract, you should carefully review how liability is apportioned between the parties in the supply chain.
Just a quick aside to look at contracts that are currently under negotiation. The courts have held that frustration isn't available, as Ali says, where the frustrating event could have been foreseen by the parties. Given the projected impact of the virus and the projections from the World Health Organization, it seems to me that we're now at a stage where a serious impact is likely to be foreseeable. To give you one example, in the case of Fly Music Company and Theatre Entertainment, a theatre company promoter based in Greece argued that its contract with a live entertainment promoter to put on performances of the West End show Thriller Live during June 2010 had been frustrated due to civil unrest. The promoter argued that the civil unrest in Greece, which was as a result of the austerity measures that had been imposed by the Greek government, was already in existence when the contract was made, and it had not really become worse during June 2010. In its judgment, the High Court agreed with this and held that it did not amount to frustration. And the judge in that case said, I'm not persuaded on the evidence that the contract was frustrated. I find that by the time it was signed, the difficulty was already sufficiently apparent, and it would have been not correct in factor and law to release the parties from their obligations under the contract. There was already significant unrest. How long it would last was uncertain. Ticket sales had already begun and they were low. There were road closures, there were already demonstrations, there was already violence. And so he's identifying areas where the parties should have ideally foreseen what was about to happen, or could have foreseen what was about to happen. This is an important point if you're currently in contractual negotiations, because obviously whilst the full impact of the coronavirus outbreak isn't known yet, there's a pretty good argument that the contracting parties should be reviewing their operations and contingency planning in response to the current situation. If the impact of the virus becomes more significant, we think that there will be real challenges for parties who attempt to rely on broad force majeure provisions or on the doctrine of frustration to try to avoid liability for their failure to perform if they entered into their contracts when they were aware of these underlying circumstances. Given the current position, our view is that the best way to try to deal with this is expressly in the contract. By having clear discussions at the outset about the potential impact of the virus, the contract can build in additional provisions to address this. For example, through variations to KPIs, increased flexibility on delivery or payment terms, or at the least certainty about which party is assuming the risk for the coronavirus outbreak, so that they can hopefully try and back that off against insurance.
So, having looked at the circumstances where force majeure and frustration might apply in the context of coronavirus, it's important to look at the impact that would have on the party's liability. As we've already mentioned, the effect of a force majeure clause will depend on how it's drafted. Normally, the effect is to suspend the obligations and liability for the duration of the event, but sometimes it can go further and allow for termination. The consequences of that event are normally also set out in the contract, and the parties will be expected to comply with them as long as it complies with any reasonable test required under UCTA or, for example, in a consumer contract, the fairness and transparency concept in the Consumer Rights Act. Frustration is slightly different. The starting point is that the effect of frustration is that the contract is automatically discharged and the parties are excused from future obligations. It doesn't rescind or unwind the contract back to their pre-contract positions. The general position adopted by the English courts is that the loss lies where it falls, making it difficult to claim for the value of a partially completed contract. Over time, the court has created general rules aimed to reduce some of the unfairness that this can create. In Scotland, the courts have been more willing to apply the law in a way that balances the interests of the parties in a fairer way. Because of the potentially significant impact of a force majeure or frustration event, it's important that you review the scope of your insurance cover. Most businesses will have some form of business interruption cover, which covers loss of profit or income because of an event outside their control. Normal business interruption cover is often subject to a material damage restriction, which requires an interruption to be caused by physical damage that's insured under the policyholder's property damage policy, such as fire or flooding. That said, some policies also include cover for interruptions caused by other factors and may cover for interruptions caused by coronavirus. Where policies do cover loss caused by the outbreak of a disease, cover is usually subject to the disease being declared a notifiable human disease. Coronavirus was declared a notifiable human disease by the UK government on the 5th of March, and as this isn't retrospective, any closure prior to that date wouldn't be covered. It's also important to consider whether COVID-19 has actually been identified at the premises. Some policies only apply if the disease has been detected at the premises that are to be closed. Others only require that there to have been an order from a competent authority that the premises be closed as a result of the disease. This can be significant because in many cases businesses will be closed as a precaution. In those situations, many businesses wouldn't benefit from the cover. It's also important for any business considering a temporary closure as a precautionary measure. This can absolutely be an appropriate measure in certain circumstances, but most policies wouldn't cover losses arising from a precautionary closure. Equally, a decision to require individuals who may have been exposed to COVID-19 to self-isolate will not be covered by most policies. If your policy does look like it covers you, it's important to note that it will usually be subject to a time excess or franchise period, which is very often a set number of hours or days. When the policy is subject to a time excess, no cover will be available for losses suffered during the period of the excess. If, however, it's expressed as a franchise period, the full loss will be recovered, provided the interruption lasts longer than the franchise period specified.
We're going to round up today's webinar with some practical points to consider, starting with steps employers can take now. Firstly, employers should take steps to prevent the spread of the virus by providing hand and surface disinfectant and displaying signs encouraging good hygiene. Employers should ensure that they communicate to employees what they need to do if they've recently travelled to a Category 1 or Category 2 country, whether that was for a personal trip or for work-related travel. Make sure that your contact details for employees are up to date in case you need to contact them at short notice, for example, to announce an office closure. There is a lot of information available in the media at the moment, so employees should be kept updated as further government advice becomes available. We are advising employers to look at reviewing their business travel policies if they've not already done so, and to consider restricting all but essential travel to at-risk areas. Employers may also want to consider whether non-urgent meetings can be cancelled or arrange to hold video calls as an alternative to meeting face-to-face. Some employers have already restricted attendance at larger events, so if you have people booked to attend a conference, you might want to consider whether this is necessary. We should be getting guidance over the weekend on the restrictions that have been announced about large events, and so we would advise to keep an eye on what that's going to say. Another important thing to do now is get in touch with your private health insurers to confirm the approach that they'll take to confirmed cases. Boris Johnson confirmed yesterday that we have now moved into the delay phase, And so in coming weeks, the government might look at implementing the population distancing strategies, which we've already had some information about, and they'll include school closures and encouraging greater remote working. The update yesterday was clear that these measures need to be implemented at the right time to coincide with the peak of the virus so that their impact is maximised. Employers should put their contingency plans in place now and make sure that arrangements for home working are in place, and that should hopefully minimise disruption. Obviously, home working does not work for all industries, and some roles simply cannot be carried out from home, in which case sick pay protection will kick in if the workplace has to be closed. Where remote or home working is possible, employers should carry out a risk assessment for doing this on a large scale if they haven't already done so. For example, will the technology be in place to support it, and do employees have access to facilities such as laptops and the ability to actually log on remotely? Training sessions can be provided for employees who do not already work from home on a regular basis, just to make sure they're comfortable with connecting and that they know how to access IT support from home. Where remote working is not possible, employers should consider whether it might be possible for staff to work at a different office or site, which is unaffected or not subject to a restriction. In concluding the employment section of today's webinar, I want to highlight the importance of employers adopting a consistent approach. This is important to avoid claims of discrimination, unfair detriment, and feelings of resentment among staff. Employers should ensure that they communicate all policies, practices, and arrangements clearly, and that they are applied equally to all employees. For example, employers should ask all employees to declare whether they've travelled to an affected country, rather than only asking those who may have family that they've visited recently in affected areas. Since the outbreak of the virus, there have been a number of reports of racist behaviour towards Chinese people, and so employers should be alive to this issue and aware of the increased risk of discrimination in the workplace at the moment. Finally, employers should consider how information of any confirmed case of coronavirus will be communicated, as they'll need to ensure that this maintains confidentiality and is in line with their privacy notice for GDPR purposes, as any data concerning health is classed as special category data.
In terms of practical steps for businesses faced with potential force majeure situations, we'd suggest undertaking a review of contracts carefully, with a particular focus on governing law provisions, as this will impact on the interpretation of any force majeure provision, or if there is no force majeure provision, what non-contractual remedies are available, the scope of any force majeure provision and steps required for invoking it, whether there's an obligation to mitigate and what you might be required to do to meet that. Again, consider the causation test and whether or not there are other contributing factors that may mean you can't rely on the force majeure clause. As Matt mentioned, the notice requirements, particularly the point at which notice would need to be given, and also the longer-term consequences on the relationship, for example, if it would ultimately result in possible termination.
And in particular, in the context of force majeure, consideration also needs to be given to whether declaring a force majeure event under a contract or receiving a force majeure claim from a counterparty impacts on your insurance arrangements. Also, whether there may be any wider reputational risks and potential damage to long-term supplier relationships if the force majeure clause is invoked. The drafting of force majeure clauses in any new contract should obviously also now be considered, and it should be looked at very carefully, and if relevant, consider agreeing specifically with the counterparty what the position should be if either party is affected by the coronavirus outbreak, and reflecting that in the agreement in the contract.
More generally, other steps to consider taking are reviewing your business continuity and disaster recovery policies and arrangements, and those of key suppliers, to ensure suitable plans are in place to reduce the impact of the outbreak. Ensuring that you're monitoring the development of the outbreak and measures taken not only in your own jurisdiction, but those of your key suppliers and customers. You should also consider other supply options where relevant, or cancelling or reducing orders. This should be done in a way that doesn't breach or undermine your existing contracts or arrangements. You could also discuss realistic delivery schedules with suppliers and buyers, and keep in regular contact with these parties and any logistics partners. It may also be appropriate to agree variations to certain contracts and these variations may apply kind of temporarily whilst business is affected by the outbreak. If you're having discussions with customers, you should be providing reassurance and being careful to avoid suggesting that you are unable to meet your contractual obligations, as this may provide the customer with a right to terminate under the agreement.
So that concludes today's webinar, and there's now going to be an opportunity for you to ask questions. As I mentioned at the beginning, questions can be submitted by typing in the chat box. We also appreciate that things are going to continue to develop pretty quickly in the coming weeks and months. So if you do have any follow-up questions after today's webinar, feel free to contact one of us and we'll be happy to help. I think because we've gone over time for today, we're trying to keep it to 30 minutes, but obviously there's quite a lot to cover at the moment. We'll maybe just wrap it up, but what we'll do is we'll leave the chat box open after we close today's webinar, just to give everyone a chance to put their questions in. And then what we'll do is we'll pick up with you all separately afterwards, just to respond to those questions direct. So with that, thank you very much for attending today's webinar, and we'll close it there.